Rob is a First Amendment lawyer, longtime advocate for the news media, and a former journalist at the late, great Holyoke Transcript and whatever. Come on up, Rob. Thank you.
Thank you, Tom. Good afternoon. This is a story about passion and persistence, about a father's love for his child, and about his determination that the government can and must do better. Michael Ciampa began his career as a social studies teacher, and he's the father of 3 children, one of whom, a daughter, has special needs. He believed that the town of Weston, Massachusetts, despite a reputation for excellence in its general education services, was not doing right for the special ed population in the school system. So Michael made a public records request for copies of privately negotiated settlement agreements between the school district and parents of special needs children. The agreements related to apportionment of the expenses for out-of-district school placements for those children. He made the request on January 17, 2012, and 13 days later received, as no journalist here will be surprised to learn, a flat denial. The school district's position was that the information, which involved expenditure of taxpayer funds, was not a matter of public record, and that disclosure of the requested records would violate state and federal privacy laws regarding educational records. So Michael appealed to the Massachusetts Supervisor of Public Records, who, in a pattern that may also sound depressingly familiar to many of the journalists in this room, backed the school district's position, saying the records sought were indeed exempt from disclosure. So much for that appeal mechanism. But Michael wasn't about to take no for an answer. So in a state, Massachusetts, renowned for its weak public records law, he invested his own funds, he hired a lawyer, and he took his case to the Superior Court. And there he obtained vindication, a ruling that, subject to certain redactions to protect student privacy, the documents sought were indeed public records subject to disclosure under the Massachusetts Public Records Law. The school district appealed, of course. These stories are never short. The Supreme Judicial Court took the case. The ACLU and the Attorney General and the Massachusetts Association of School Committees weighed in with amicus briefs. And ultimately, in a unanimous ruling, the Supreme Judicial Court ruled in Michael Ciampa's favor. Quote, "The public has a right to know the financial terms of these agreements," the court said. Now, I want to just put this victory in perspective. In Ciampa against Weston Public Schools, decided on October 23, 2015, the SJC did not simply provide relief for Michael Ciampa and other citizens seeking empirical data about the fairness of special ed services. The court also affirmed 2 important principles relating to public records. First, the court reaffirmed the principle that even if a document falls within the coverage of a public records exemption, still it must be turned over if the exempt material can be redacted out in order to enable the release of the remaining portions. Quote, "Under the public records law, any segregable portion of the record must be disclosed if with the redaction it independently is a public record." And that's an important principle that we all rely on. Secondly, the court said that the school district can't block disclosure by slipping non-disclosure agreements into its agreements with parents. The court acknowledged that the agreements may have served as a private settlement of a dispute, but it went on to say that the fact that the school district and the family contractually agreed to keep the settlement private cannot by itself trump the public records law and the school district's obligation to comply with the law's requirements. That's important language that we can expect to see lawyers relying on in Massachusetts and perhaps elsewhere to counteract the tendency of municipalities to try to cloak in secrecy the settlements of matters involving the payment of taxpayer dollars. NEFAC's Citizenship Award is named after Dr. Antonia Orfield, who was herself a parent and an active citizen who worked to help children with learning difficulties. It is fitting, then, that this year's Antonia Orfield Citizenship Award should go to Michael Champa, a caring father whose passionate desire for special education parity led him to wage a public records fight, the outcome of which will benefit those of us in this room for years to come. Please join me in recognizing Michael Champa.
Sounds so official. After years and years of fighting, I get to have a chicken dinner and a nice meal. Thank you, Rob, and congratulations to my fellow award recipient, Senator Patrick Leahy of Vermont, and investigative journalist Jennifer McKim. I'm honored and humbled to be on the same stage and to be mentioned alongside former Orfield Award recipients Harriet Cady, Kit Savage, and David Lang. In the push to improve public access, we forget that public access has a face. In our case, it was the face of our 14-year-old daughter, Caroline, who's sitting right over there. It's the face of ordinary citizens trying to understand their government in order to make an informed decision or to expose a wrong. It's a discovery process often dearly earned and grounded in a basic American right to unfettered access to their government. It seems that government officials sometimes forget that the preamble to our Constitution begins with the words, "We the people." Our public access journey began more than 5 years ago, 5 long years ago, when Caroline was denied educational services by our public school district that we and a panel of experts believed she needed. As we researched the alternatives and tried to work with our school system, it became increasingly apparent that we did not have the information we needed to make an informed decision, and there was no way to determine if the school system was acting properly. Requests for information often went unanswered, and the district refused to provide the kind of data that any parent would want when trying to decide the fate of their young child, or when trying to establish the quality of their school system. We had no choice, and we made the decision to file a public records lawsuit. It is important to note, however, that over the last 45 years, Congress and our state legislature have come a long way to provide protections for the disabled and those with learning disabilities. In fact, many would say that Massachusetts ranks among the best in that regard. But as these programs have developed and the budget impacts of these programs better understood, local school districts have learned how to minimize, some would say avoid, their responsibility under the law. What's worse, school districts properly concerned with student confidentiality have been unwilling to share information about the implementation of their programs or the extent of the services offered. School districts have resorted to negotiating private settlement agreements with parents. Everybody's cutting their own deal. Agreements that until my SJC case was decided were strictly confidential and not subject to public review. It was my belief that these documents should be available to the public as long as they were properly redacted to protect student identities. The agreements, after all, obligated public school districts across the state to tens of millions of dollars. Money to this day is being spent with not one bit of public oversight, nor are there any checks and balances in place to ensure that children are being treated equally and fairly, and that the intent of our special education laws is being enforced. As Rob mentioned, on October 23rd of 2015, the SJC upheld a lower court decision and ordered Weston Public Schools to release the redacted settlement agreements. We finally had those documents in our hands. A review of the agreements revealed what we had feared most. Kids were not being treated fairly or equally, and parents are increasingly being required to assume the cost of educating their special needs children, despite the statutory guarantee, a statutory guarantee of free and appropriate public education. Just as importantly, those without legal resources to negotiate are often closed out of the process. The rich get more, and the poor often get nothing. I want to remind you that all of this happened in Weston, Pleasantville, just west on Route 128. Not exactly the mean streets of the inner city. I can only imagine and fear what's happening in less affluent communities where parents are unable to afford the lawyers or advocates to negotiate on their behalf. Litigation took 3 years, countless meetings, strained conversations with school administrators, and occasionally my wife, and close to $80,000 in legal fees. I think it's 80,000. I stopped counting a long time ago. This can't continue. It just cannot continue. And an improved public records law needs to address both the amount of time required to resolve these issues and provide reimbursement of legal expenses in cases where municipalities unjustly withhold documents. I urge all of you to talk to your legislators to support an amended and strengthened Massachusetts public records law, which is currently under consideration on Beacon Hill. We won our case, but the job is far from finished. Now that we have the information and the SJC legal precedent, we can begin to accumulate the data required for a serious review of what I consider to be a seriously flawed component of our special education laws. Without the data obtained through this public records request and the SJC order, it would be virtually impossible to make a case for new legislation. Public access to these documents exposed a problem, a big problem, and that will ultimately point towards a legislative cure. For our family and for the special education community, it was a victory earned at what many would consider a staggering cost, but well worth it if it furthers the cause of public access and the fair treatment of all of our children in all of our public schools. And finally, a positive postscript to the story. I'm sure you remember my daughter, Caroline. Stand up. Well, Caroline made the high honor roll at her school the last 2 quarters. Thank you all for coming, and again, thank you to the New England First Amendment Coalition.
Congratulations, Michael, and thank you. Last September 19th, readers of the Boston Globe opened up their papers or went to the online site and read a horrible story about 110 children who had died of abuse and neglect. A third of those children had been at some point under the watch of the State Department of Children and Families. Many others likely had been known to the state, but had somehow dropped out of supervision. I'm going to read an excerpt from that story that I think gets to the heart of why we are honoring Jennifer McKim. The story says, records obtained by the New England Center for Investigative Reporting show that the vast majority of the dead were under the age of 3. They had been beaten, drowned, smothered, or otherwise abused and neglected by caretakers, and their numbers have steadily increased. Records show from 14 reported abuse or neglect cases in 2009 to 38 in 2013, and state officials say the number will likely remain elevated when last year's death toll is made public. That article told the story, again, of each of the 110 children who had died. Online, the reader had an opportunity to actually go to an interactive site and read individually and see the pictures of each of the children. It was a heartbreaking story. But even more so, it exposed weaknesses in the State Department of Children and Families process, where would categorize the needs of the children in two ways. One would be those children that deserve the state's highest attention. They were probably in extreme danger, and those children who were accorded a lesser degree of exposure, of vulnerability, and those families were often assigned a less experienced caseworker, and oftentimes the caseworker's mission was to keep a family together as opposed to try to protect, first and foremost, the interest of the child. That story almost immediately caused Governor Baker to change the process within the department so that that kind of a categorization didn't take place. And again, I think it's characteristic of the importance of the work that Jennifer has done with the New England Center for Investigative Reporting and its partners. There's a saying in journalism that the role of a journalist is to afflict the comfortable and comfort the afflicted, and others that the role is to be a voice for the voiceless. And that, I think, in many ways is exactly what Jennifer McKim has done throughout her career. Prior to coming to the New England Center for Investigative Reporting, she was on staff at the Boston Globe, again doing a remarkable, important work about people who were voiceless or children who were vulnerable. Prior to going to the Globe, she was a reporter at the Orange County Register, and she was a finalist for the Pulitzer Prize in 2005 for a series of stories called Toxic Treats, and it was about candies that that had lead in them that were being distributed to children with virtually no safeguards whatsoever. And I'm sure you recognize the long-term implications of children eating candy with lead. Again, that story immediately caused changes in prohibiting that kind of candy being done. Some of you more recently may be familiar with the story that Jennifer did in collaboration with several staff members at WBUR about the case of Darren Jones, who has been sentenced to life in prison for murder. And with the stories that appeared again on WBUR, I think have raised significant questions about whether there was virtually any evidence whatsoever to convict him of the crime for which he is being held. That case is subject to being reopened and under review. But again, I think it goes back to the interest and the passion that Jennifer McKim has shown for being the voice for the voiceless and afflicting the comfortable in many ways. So we're delighted and honored to be able to present Jennifer with this year's First Amendment Award. Jennifer? I have to say one more thing. Jennifer is a graduate of Wesleyan, and she started her journalism career by immediately going to Puerto Rico and joining, was it El Nuevo Dia or the San Juan Star? So she learned journalism in the same place Hunter Thompson did, but she's done much more with it. So anyway, Jennifer.
Wow, thank you so much, Tom. What a great introduction, and thank you to the New England First Amendment Coalition. This is a great honor to be up here with Michael Chiampa and with the Senator and following the footsteps of such great journalists like James Foley, who was honored here. It means so much to be honored for the hard work we do at the New England Center for Investigative Reporting, fighting for the public right to know, especially when we are bringing to light problems with the state's ability to protect one of its most powerless constituencies, at-risk children. The idea behind the Federal Child Abuse Prevention and Treatment Act, which requires states to provide limited information about children it believes died of abuse and neglect, is to prevent the next death of a child murdered, drowned, suffocated, or otherwise mistreated by an adult caretaker. But the Massachusetts Department of Children and Families did not easily release information about 8-month-old William James Berry of Lowell, who was shaken to death in 2013 by his father, a U.S. Army veteran suffering from post-traumatic stress, a month after state social workers had been alerted to troubles at his home. Nor did state officials quickly provide details about the life and death of little Dejalis Alcantara, a 6-month-old girl from Dorchester, who was under social worker supervision when she died in 2012 of hyperthermia, wrapped up in blankets in the back seat of a running SUV in a KFC parking lot. Her allegedly intoxicated mother passed out in the front seat. Indeed, it was only after the New England Center for Investigative Reporting, with the enormous help of our pro bono attorney, Jeffrey Pyle from Prince Lobel, and ongoing support from the Boston Globe and Spotlight investigative editor, Scott Allen, after months of negotiations, pressure, cajoling, and the payment of $4,500 that the state belatedly started to release information about the 110 children it believes died of abuse and neglect in Massachusetts between 2009 and 2013. It was only then, nearly a year after our original request and with a new governor, the details began to slowly emerge of children whose stories had not been heard, about a third of them who had been at some point in their short lives under the watch of the state, tasked with protecting them. And what we discovered with a small team of interns and dedicated staff here at NECIR, many of them sitting at this table, was a series of missteps, missed opportunities, and systemic flaws that failed to save children who, in the end, had nobody to protect them. We learned that a month before William died, social workers, alerted to possible neglect in his household, confirmed problems and put him on a troubled lower risk track launched in 2009 for children less in danger but more in need of family preservation services. We found that 10 children during this period died on this so-called family-friendly track, a system long criticized by the Social Workers Union, who feared vulnerable children were falling through the cracks. After poring through state social workers' guidelines, we found that workers were not even required to review criminal histories of caretakers, like William's father, who had been the target of a call that a child was in danger. If they had, they would have found court records that revealed he was unraveling after suicide bombing in Afghanistan and charged, among other issues, with domestic violence and animal cruelty. Yet the information that the state provided to us, we believe, was flawed. There's still more to learn. It simply provided the name of the child who died, the date, cause, and town of death, any confirmed history of abuse and neglect, and services provided by the state. But DCF officials have refused to give us still, and we've asked repeatedly, more details about calls of concern involving children who died of maltreatment that the state decided were not worthy of following up on. We're still fighting this case and looking for ways to move it forward. As with Michael Ciampa, the Secretary of State has rejected this appeal. Child advocates like Michael Petit, who sits on the Federal Commission to Eliminate Child Abuse and Neglect Fatalities, says states should be more open rather than less, that the veil of secrecy be lifted. We are still striving to obtain this information and believe it's imperative to analyzing the government's ability to protect children. When our stories ran, I'm gratified to say public officials did take notice. Governor Charlie Baker soon after announced that criminal history checks would be required for all calls of alleged maltreatment made to social services, and the two-tier system was eliminated completely. Our investigation added to the mounting evidence and public scrutiny made evident in other powerful stories of dead and abused children, including the woeful tale of Bella Bond, first only known as Baby Doe, found in a trash bag in Boston Harbor. These stories that show clearly that the state social services system needs to be revamped. At the end of the month, the state is launching a new system to assess children's risks and protect children. I can assure you that we will be part of that watchdog team that follows its progress. I'm honored to work at the New England Center for Investigative Reporting, one of the first nonprofit newsrooms in the country and one of the most sustainable. Enormous thanks to my editor on these stories, Clara Germani, who worked countless hours going through this work, Nesser co-founder and executive director Joe Bergantino, who brought me here, and I'm very thankful for it. Our dedicated board, led by Chairman Bill Ketter, who's also here, Boston University, and especially Tom Fiedler, and all our partners, WGBH, as well as WBUR and the Boston Globe, for providing us the resources and support to do this work, writing stories that make a difference and educating a new generation of investigative reporters. As the legislature mulls new regulations to strengthen the state's dismal public records laws, I urge all of us in this room to continue the public pressure so stories like those of William, DeJalice, and Baby Doe do not have to be repeated. Thank you for honoring this work, and thank you again to the New England First Amendment Coalition.
Thank you, Jennifer. Very well said. We're going to have a slight addition to the program here. As you may have noticed, the awards for that Michael Ciampa has received and the one that we will be giving to Senator Leahy are named after people, after donors who have been generous and particularly in focusing attention in this area. Today, we're honored to actually name the Freedom of Information Award. And it'll be named after a colleague of ours in the New England First Amendment Coalition, and a name that virtually everyone in the state of Vermont knows well, Michael Donohue. And some of you may know Michael truly is someone who has lived a life in a newsroom. He started as a clerk in the Burlington Free Press in 1968, joined the staff full-time in 1970, and then took out a long-term lease on a desk in that newsroom, and stayed there until retiring just really a few weeks ago after 47 years a career again at the Burlington Free Press. He has been involved in virtually every major public records issue in the state of Vermont during that time. In fact, in many ways, he mentored so many others who came to use the Freedom of Information Act tools. In fact, Michael said that he had it as a personal goal not to let a single week go by when he didn't file an FOI for something somewhere. The work that he has done has had, again, an uncalculable impact. He's been a member of the Vermont Press Association for 35 years and was the executive director for a period of time. He has been the state chair of Project Sunshine, which is a project that the Society of Professional Journalists do to attempt to show how public records work in various states, and he's been a member of the board of the New England First Amendment Coalition since its inception. Again, we're delighted to be able to honor him with this award. I want to read one editorial that was written when his retirement was announced. It appeared in the Stowe Reporter and the Waterbury Record. It goes on to say, "He has been an extraordinary digger, uncovering corrupt officers on state and local police forces, a hazing scandal involving the University of Vermont hockey team," that made you very popular, I'm sure, Michael, "and how the justice system compounded the terrible experiences of rape victims. He prompted a change in state drunken driving laws when he found a 16-time DUI offender was still free to roam around the state. Donohue is retiring this week," the editorial went on to say. "There's nobody like him in New England journalism, and there may never be again. It's doubtful that anyone will ever have his insatiable curiosity, sense of justice, and dogged refusal to take no for an answer." Again, we're delighted to be able to honor Michael by naming the FOI award after you. Michael? And Michael will introduce our next speaker.
Thank you very much, and Jennifer, Michael, you're my kind of people. This is a wonderful way to sort of cap off a career, although I have to admit that in retirement I've already filed 2 public records requests. You know, I will say that I did get an interest early on when the governor of Vermont at the time refused to give me his list of governor's pardons, and I was told there was 40 of them, and 21 months later, the list was given to us, and there was nearly 300. So I learned public records are the way to actually find out what the real truth is. And as Peter Shumlin, the governor, said as I retired, he said, Mike Donahue has never seen a public record that he didn't love and didn't request. So it's my pleasure today to introduce, I always love this phrase, a man who needs no introduction. So that's when I usually sit down, you know, or something like that. But I will say Senator Patrick J. Leahy, Vermont's senior senator, is known for his love of the First Amendment and freedom of information. As Senator Leahy says, it's in my blood, and literally it is. After all, his parents operated the Leahy Press in Montpelier for several decades. Senator Leahy graduated from St. Michael's College in 1961, later went on to Georgetown Law School. And of course, it was at St. Michael's that he met Marcel Parmelo, who would become the love of his life. Senator Leahy and Marcel were featured on Valentine's Day in the Burlington Free Press with their love story. And as the senator loves to say, Marcel and I, and they are a great team with 3 wonderful kids and several grandchildren. And Marcel is a nurse, and I got to tell you, I've had some health issues since I retired, and including a heart attack in church on one Sunday. And when I came to and I looked up, Marcel, the nurse, was there, and the senator. So, Senator, next time you run, I'm actually writing in Marcel's name. So, since you are a team, hope the vote counts. Senator Leahy quickly built a reputation as being a fair and hard-nosed prosecutor after he was appointed Chittenden County State's Attorney, the state's busiest court. He spent 8 years in the post and was nationally recognized by the National District Attorneys Association as one of the 3 top prosecutors in 1974. He operated without fear or favor. He brought down Vermont's biggest lying drug cop. He actually prosecuted a former Democratic governor for driving under the influence, and he refused to look the other way when people asked him to. It just wasn't in his DNA. I can tell you all prosecutors in Vermont have been measured against Patrick Leahy ever since he was in office. He was elected as the first Democratic U.S. Senator in Vermont history in November 1974, and he's been the only Democratic senator in Vermont history. And for 3 years, he served as the longest, he has been the longest serving senator in the U.S. Senate currently. He is built on his reputation of his longstanding belief of the First Amendment and the need of the media being informed. He has always been a leader in efforts to improve and update the Federal Freedom of Information Act. He has worked tirelessly on that and other issues. And by the way, he's a great news photographer. If you ever need pictures, his pictures have appeared in Time, USA Today, and a whole bunch of other places. He's worked on federal shield laws. He's favored bringing cameras into federal courts. He authored the 2010 Speech Act, which protects American journalists who are sued in foreign countries. There's a bunch more in the program. I'm not going to take a lot more. He's been honored by several journalism groups, National Society of Professional Journalists. He won the Matthew Lyon Award. He's in the FOI Hall of Fame. He's won the John Peter Zanger Award, and we are lucky to have him here today. Senator Leahy is the ranking member of the Senate Judiciary Committee, which means he'll be front and center for the next few months probably, as the President tries to appoint a Supreme Court justice. I'd like to acknowledge the Stephen Hamlet family for their support here today of NEFAC and the First Amendment. And with that, it is a great honor to introduce the 2016 Stephen Hamlet First Amendment Award winner, U.S. Senator Patrick J. Leahy.
Mike, thank you very, very much. I appreciated that introduction. I know Marcel appreciated it too. It's nice to hear those things while you're around, and I appreciate it. But I'm glad to see the Freedom of Information Awards now going to carry your name. Those of us in Vermont know that Mike is absolutely fearless. He's relentless. He's merciless. I mean that in a good way, I hasten to say, and digging for information. Mike's dad was one of my professors at St. Michael's College, and I remember his insistence on thoroughness and accuracy, and both Mike's photo and his dad's, Marcel and I were noticing this morning, are out on the board. And I think, Mike, your late father, Professor Donahue, would be very proud of his son and that you carried out the values he believed in. But I also want to thank the New England First Amendment Coalition, all the coalition's partners, and Tom Fiedler for all the important work you do. It's an honor to share this podium with two other New England FOIA defenders and users, Jennifer McKim and Michael Champa. And I apologize for this laryngitis, but it's nice to see so many Vermonters and other friends in the room. Al Getler, the new publisher and president of the Burlington Free Press. Marcel's cousin, Patricia Parmelo, lives here in Burlington, was able to join us. And getting an award named for Stephen Hamlet, Mrs. Hamlet, it's nice to be here with you. It was nice to hear your stories. And I am going to repeat, if you don't mind, not here, but that story about your husband when he was getting piled a little bit too high and what he did. I think that you may even see me leaning over and doing that during a Senate hearing in Washington. You know, I'm the son of Vermont printers, so I feel like I'm among family. I learned from a young age the importance of the freedom of speech. Actually, to me, the First Amendment is the most sacred part of our Constitution. It's really the foundation of our democracy and our way of life. If you guarantee a free press, the First Amendment makes possible an informed electorate. Now, we in New England know what that's about. New England has made an indelible mark in the history of courageous American journalism. Elijah Lovejoy, who refused to stop publishing abolitionist material in his newspaper, paid with his life. He became our nation's first martyr to press freedom. But we also follow in the footsteps of such greats as William Lloyd Garrison, editor of The Liberator, such workhorses as your husband, Stephen Hamlet, for whom the honor is named. I think of the late and great Tony Lewis. I think of one of my favorite cartoonists, the incomparable Jeff Danziger. And I think of Pulitzer Prize-winning editorial writer David Moats of Vermont's Rutland Daily Herald. They courageously illuminated Vermont's debate over civil unions with their editorial, Stafford's Gift. And it was a gift to all Vermonters. And when I think of the First Amendment's importance, I also think we all should about freedom of religion. My mother's parents immigrated to Vermont from Italy in the last part of the 19th century. Now, Vermont was a different place back then, I am told. My grandparents were often met with suspicion because they were seen as papists, and they spoke a strange language, even though my grandfather spoke and read and wrote many languages. Catholics were not looked upon favorably. There is no Catholic church in my grandparents' town. So every few weeks on a Sunday, a Catholic priest from another town would come to my grandparents' home. They'd pull the blinds. All of the Italians in the area, many of whom worked for my grandfather, would come to hear Mass. And my father's grandparents came to Vermont from Ireland. When my grandfather, Patrick J. Leahy, died in the early part of the 20th century, my father was just a teenager. So I never knew the man I was named after. My father had to leave work as a teenager, leave school rather, and seek work in Montpelier to support his mother and younger sister. A lot of the businesses had signs that said, "No Irish need apply." More direct ones said, very obviously, "No Catholic need apply." It's almost redundant to say Irish and Catholic at that time. But my father persevered, and he and my mother began a weekly newspaper, the Waterbury Record. And one year it was published on St. Patrick's Day. He printed the paper in green ink. I think it's his way of saying the Irish got it hired after all. They then ran a small printing business, the Leahy Press. I mention all this history because in our family, the First Amendment was an article of faith. We were taught that people have a right to practice any religion they want, or none if they want it. And we were taught that in the United States, everyone is guaranteed the right to speak, even if your speech is unpopular. The Leahys believed, and this Leahy certainly believes, that if you guarantee, and this is why the First Amendment is a touchstone, if you guarantee the freedoms of religion and speech, you guarantee diversity. If you guarantee diversity, then you protect democracy. Think of the countries that haven't protected those two, and look how they've spun out of control. Now, as journalists, you live out that commitment to free speech every day. And like legislating, it's not always easy work. But if you have a determined news team, you can have a tremendous impact. After all, it was the Boston Globe Spotlight team that uncovered years of abuse that took place in the Boston Catholic Archdiocese. That reporting rocked the whole world. It led to revelations of sexual abuse in dioceses across the country, including in depth in Vermont. That had been covered up by the Catholic bishop of the time. And now I know the Vermont Free Press covered very extensively the trials that resulted. So the significance of the Globe's coverage can't be overstated, but nor can the importance of a free and open press. But at the times of great fear and stress in our nation's history, some want to stray from this core value. Don't ever let them do that. Remember what happens when leaders succumb to the politics of fear, that they lose sight of our fundamental American values. Joseph McCarthy did this when he leveled an attack on anyone who challenged him, including journalists. J. Edgar Hoover did the same when he targeted Martin Luther King or those he suspected might be gay. Now, we're a long way from the days of McCarthy and Hoover, but there are some who want to again stoke fear for political gains. And those who challenge these fears are going to be attacked, including journalists. Heck, for that matter, even the Pope. But, that's a little editorial comment. But we have an obligation to stand up for American values in these moments. That's why when a leading presidential candidate declared that we should ban all Muslims from entering this country, I offered an amendment in the Judiciary Committee plainly stating that America does not bar individuals based on their religion. It's a simple, straightforward amendment, and I'm pleased that most members, Democratic and Republican alike, support it because it underscored the freedoms in the First Amendment. Those aren't pick and choose freedoms. Those are blanket freedoms, just as you don't pick and choose what you can write about and say. It's a blanket freedom. And we know this in this country, but look what's happened abroad, how critical the press is in fighting against human rights abroad. And without a free press, corruption and erosion of the rule of law lacks public accountability. In Ecuador, President Correa has waged a relentless campaign to silence his critics. His government went so far as to bring a lawsuit against a popular political cartoonist because he dared criticize him. Man, how many cartoonists would go out of business around here if we did that in the United States? I've repeatedly spoken out against this. I support individuals like Vietnam's human rights and free press advocate Lee Quoc Nguyen. He and other Vietnamese have been jailed for exercising their right, even though it's enshrined in the Universal Declaration of Human Rights, to free expression. And I've raised that point in Hanoi to the leaders of that country. Because if you don't protect journalists, here's what happens. The Committee to Protect Journalists documents that 199 journalists were jailed last year. China and Egypt are the worst offenders. In the past decade, 700 journalists have been killed for trying to bring information to the public. That's a sobering number. That's an average of one every single week. But you know what's even more sobering? Because they don't trust the press and they don't care for the press and they don't protect the press in those countries, in 9 out of 10 of those cases, the killers went unpunished. Now, as Mike said, I was a prosecutor. I'm now a senator. I don't want to just support the ideals of the First Amendment. I want to protect them. My very first vote in the Senate was in favor of the Church Committee, which provided vital oversight of government surveillance. And my commitment to transparency and accountability has not stopped since that first vote. Since then, I've cast over 15,000 votes. But any vote that touches on the First Amendment is my priority. In fact, after years of fighting to rein in the bulk collection of Americans' phone data, we finally secured passage last year of the USA Freedom Act, which I helped write. I've joined with Republicans and Democrats to strengthen the Freedom of Information Act. And each step we've made on that, I've had an equal number of Republican and Democratic co-sponsors, and we'll continue doing that. FOIA is important no matter which party controls the White House or the Congress, because we'll all be ready to give out press releases of things we've done right. We don't really want you to talk about the things where we screwed up. That's where you have FOIA. We live in times that test government of and by and for the people. Dark money floods our political process. Cynical efforts to squeeze access to the right to vote dampen public participation. And the crucial third leg, government accountability, requires unending struggle to defend the public's right to know. Sunshine, not secrecy, should be the default setting. It's easy to state these principles. Living up to them is much harder than it sounds. War correspondents, they put their lives on the line to tell the important stories from conflict zones. Repressive regimes are often able to silence or kill courageous reporters with impunity. Media outlets, every one of you have to figure out your bottom line. You know you have to do more with less, but you have to work hard every day to make sure readers are informed. But all of us have to be vigilant because there will always be efforts to stifle the freedoms promised in the First Amendment. Just this one time, we shouldn't talk about this. Just this one thing should not be in the press. Baloney. The First Amendment covers all, and that's a fight worth fighting. Now, last Saturday, we learned of the sudden passing of Justice Antonin Scalia. While I disagreed with him on many things, I agreed with him and told him many times I like the fact he stood up for the First Amendment. Now, today, thousands of Americans will pay their respect in the very building where so many historic arguments were heard over the reach and meaning of the First Amendment. I recall the pride of the Italian-American community when he was nominated to the Supreme Court. Shows how far we've come since the days of no Catholic need apply. But unfortunately, within hours of Justice Scalia's death, the Senate Republican Majority Leader declared the Senate would not fulfill its constitutional duty to consider a Supreme Court nominee until after the election. To preemptively reject any consideration of the next Supreme Court justice is unprecedented. It's dangerous. I don't want that to succeed. We only had once in our history we went a year with a vacancy in the Supreme Court, and that was during and because of the Civil War. Do we really want that to be our precedent? The Supreme Court is far too important to our democracy to have a vacancy for more than a year. But it's also critical to protect the very rights we're discussing here today, freedom of expression, of press, of religion. It's of course false to say the Supreme Court justices do not get confirmed in presidential election year, even though vacancies during those years are rare. We've had more than a dozen have been confirmed in presidential election years. I remember very well when the Democrats controlled the Senate in President Reagan's last year of his term, we voted unanimously to confirm his Supreme Court nominee. So let's see what happens. I've served in the Senate for more than 4 decades, on the Judiciary Committee for 36 years. Supreme Court nominees have always been given a hearing. They may be contentious, we may ask questions, the press will certainly cover it, but during those years, we've never refused to send a nominee to the full Senate for consideration. If that is done, all of us as Americans are diminished. So I will just conclude with saying, this son of Vermont printers, and I still know how to set type, I stand with all of you here today in support of our Constitution, of a free press and free expression. I'm grateful to have partners in the New England First Amendment Coalition. I applaud you for your work. I thank you. I just wish my parents could see this day. Thank you.
Thank you, Senator Leahy. Thank you for your support of the First Amendment, and thank you for all that you've done. I want to also thank Jennifer and Michael for what you have done too, and thank all of you for coming and supporting the coalition. I particularly want to thank our sponsors, and I would urge others here who might be interested in becoming sponsors to join with us. It's very important work, as the Senator has said. And thank you very much for coming. And I want to thank Justin Silverman, who's over here too, by the way, the Executive Director of NEFAC, who makes all this really happen.